Good afternoon and welcome to everyone. Whether you're in pajamas, sweatpants, or full business attire, thanks for joining us today. My name is Ben Wolkov. I'm a corporate and transactional attorney here at AXS Law Group. We obviously live in unprecedented times. We know you're here because of the uncertainty created by coronavirus and its impact on the business environment generally, and perhaps even more specifically on your business. We know it's a scary time, but hopefully information is power. And so we really hope that today will be informative and empowering. A little bit about our firm before we get started. We are a full service boutique law firm based in Wynwood, Miami, Florida. We formed AXS Law about 4 years ago with a view to disrupting the traditional law model, including by relying on technology, in order to better address the needs of the modern law, business law consumer. And we pride ourselves on providing practical and comprehensive solutions to complex business matters. Our main practice areas are corporate and transactional law, real estate law, franchise and distribution law, and litigation and dispute resolution. A couple of quick caveats at the outset. We realize that the topics we'll be discussing today, they reflect a mere fragment of the myriad legal issues that are facing businesses today. And so the topics we've selected today are based on what we thought would be most relevant to the largest number of you at this juncture of the crisis, all based on what we've been seeing from the last 2 weeks and talking to our clients. It sure feels like a long time, but as we all know, we're just at the beginning of this, and the situation is anything but static, and other issues will of course arise that will require additional attention. And for what it's worth, we intend to hold other webinars throughout the course of the crisis and beyond, and hope that you'll join us for those as well. I believe you should be able to see the names and emails of each of our presenters, so don't be shy. If you have a question as we go along, just reach out. And you'll see a Q&A tab on your screen. So feel free to post a question and we'll do our best at the end of today's webinar to answer as many of them as time permits. And of course, if we don't get to your question, feel free to follow up with any one of us. Couple of quick disclaimers. These are your typical law firm disclaimers. I apologize for them. One is this session is being recorded. And here's the really annoying one. The information provided today is not intended to constitute legal advice. All information and content is for general information purposes only. So with that behind us, allow me to introduce my colleagues, Lauren Quattromani, Andrew Cromer, Jeremy Ben-David, Morgan Ben-David, and we also have our colleague Josh Shore on from our litigation group. And although Josh won't be presenting, he's here in case any litigation related questions come up during Q&A, and also just because we really like having him around. So, and at this point, I will turn the floor over to you, Lauren.
Hello, everybody. I hope everyone's doing well and staying safe and healthy and sane during this crazy time. I'm going to be discussing contract enforceability, including force majeure provisions and other legal doctrines that can be used to excuse performance obligations under contracts. So one of the biggest issues that we're seeing arise as a result of COVID-19, and that we can expect to see much more of in the upcoming weeks, is that certain parties are unable to perform their obligations under contracts that were entered into prior to the COVID-19 pandemic. This is mostly due to a lot of the ongoing shutdowns of businesses across the country and a lack of human resources as people are staying home. And in particular, we're seeing a really heavy impact on manufacturing and supply contracts, leases, which Jeremy is going to get into, and contracts in travel and hospitality industries. So what do you do if you're one of these parties that's unable to perform your contractual obligations, or if you have a contract with another party that's failing to perform? The first thing you want to look at is if you have a written contract, whether that contract contains a provision for what's called force majeure. And a force majeure provision is going to explicitly excuse a party's performance of its obligations under a contract in the event that certain circumstances arise beyond such party's control. For example, a typical force majeure provision will say something to the effect of, no party will be liable or responsible to the other party or will have been deemed to have breached the agreement if any of the following events occur. And then we'll go on to list a number of different events that the parties will choose to include so that performance would be excused upon their occurrence. Typical events that you'll see usually listed in these types of clauses are for natural disasters, labor strikes, sometimes pandemics and other illnesses, and then some more broad language, which I'll get into in a little bit. So whether a force majeure provision will excuse non-performance for the current pandemic will depend on a couple of factors. First, does the event fall specifically within the definition of force majeure that you have in your contract? While it is very unlikely that any of your prior drafted contracts contain an explicit carve out for COVID-19, because it was not the most foreseeable thing to happen, you may have some language in there that refers to either a pandemic, an epidemic, serious illness, plague, disease, or outbreak. And this is obviously the most clear situation where you would be excused from performance because of this explicit language addressing the pandemic within this clause. If the clause doesn't contain any of that language, you can then look to see if the force majeure provision contains any sort of carve out for government acts such as a civil or a national emergency. The federal government declared a national emergency on March 13th. However, state and local governments have all had varying reactions of different severity on the issue. Government orders requiring businesses to shut down will strengthen force majeure arguments, while less serious action and partial shutdowns are going to be more of a gray area. And then lastly, a lot of these force majeure definitions will include broader catch-all language, such as an act of God, or if there's just simply circumstances beyond a party's control. And how this language is going to be construed, whether broadly or narrowly, is really going to depend on what jurisdiction you're in and what the courts in that jurisdiction or how they've interpreted this clause in the past. For example, Florida is known to more narrowly construe these provisions and take the position that if the parties could have foreseen the event as happening, for instance, hurricanes are probably a typical one in Florida, they should have probably expressly set those out in the contract to relieve themselves of liability. And it's worth noting that typically market conditions and financial inability to perform is not typically excused under this broad catch-all language. So if possible, you definitely want to see if you can rely on more specific language, such as specifically identifying a pandemic or a certain government act, rather than relying on some sort of financial inability to perform. So if you have gone through the exercise of looking over your contract and it does not include a force majeure provision, what next? There's a couple of legal doctrines that you may be able to rely on to excuse performance in the event your contract fails to include a force majeure provision. And note that the availability of these is also going to depend on the jurisdiction. So just know that going in as well. The first doctrine is impossibility of performance. This is applicable, obviously, when a party is objectively unable to perform because it's objectively impossible. And this doctrine is also triggered when performance is made illegal. So a lot of these shelter-at-home orders that you're seeing could trigger this type of defense. Commercial impracticability is a similar doctrine that will relieve a party's obligation to perform when performance is made impracticable by an event not caused by the party, and the non-occurrence of that event was a basic assumption upon which the contract was based. And again, financial impracticability usually does not trigger this, so you probably want to stay away from that sort of argument. And lastly is the frustration of purpose doctrine. This is available if the purpose of the contract is frustrated due to unforeseen circumstances or events. Courts are typically reluctant to find that a contract has been frustrated, though, and an express provision in your contract, such as a force majeure provision, will normally prevent the contract from being found to be frustrated. However, that being said, the bar for meeting this doctrine will likely be met in some situations arising from COVID-19. For example, if there's state-imposed lockdowns and parties are not able to perform. So in summary, when analyzing the enforceability of your contract, I would take the following steps. I would first look to see if you have an explicit force majeure provision and see if it has any of that good pandemic or government action language. And if the contract fails to include that, I would then try and see if it could fall under one of these other doctrines of impossibility, impracticability, or frustration of purpose. And just lastly, two other things that you want to pay attention to is whether any mitigation duties apply. So oftentimes parties claiming relief under force majeure provisions might also be under a duty to show that they took reasonable steps to mitigate or avoid the effects of whatever event took place. And lastly, make sure you're complying with any applicable notice provisions. So some contracts will make prompt notice within a certain amount of days a condition precedent to obtaining relief under a force majeure provision. So you definitely want to be knowledgeable about whether any of those provisions apply and how much notice that you need to give under such provisions. So with that, I will hand the mic over to my colleague Jeremy to talk about leases and commercial rents.
Great, thanks, Lauren. Hello, everybody. My name is Jeremy Ben David. I'm a partner here at AXS Law. My practice is transactional based with a focus on real estate law, and I deal with a lot of commercial leases, both on the tenant and landlord side. Before I start, just one more housekeeping item. Not sure if Ben got mentioned this, but there is a Q&A toggle on the bottom of your screen. If you have questions, feel free to drop them into that option. We'll take a look at them and answer as many questions as we can at the end of the webinar. So diving in. So since this pandemic started, one of the more frequent phone calls that I've received is from tenants questioning whether they need to pay rent. And my answer to them is to always check your lease first. In the slim chance that there is express language within the body of the document in the force majeure provision that would relieve the tenant from paying rent in the event of a pandemic, then that's pretty strong language to rely on. However, in my experience, working with both landlords and tenants, force majeure never relieves, or I should say very rarely relieves tenants from their obligation to pay rent. So if you can't find that within your body of your lease, you can then possibly withhold rent based upon one of the legal doctrines that Lauren just mentioned: impossibility of performance, frustration of purpose, impracticability. I won't spend some time here reiterating those, because I think Lauren did a very good job explaining those legal doctrines. But you guys should know that the application of each of these defenses depends on whether the anticipated circumstance has made the performance of the contract materially different from what one should reasonably have contemplated when they entered into the contract. In the context of the COVID-19 outbreak, nobody in their right mind could have predicted or anticipated these circumstances. So these doctrines may be something you could rely on and withhold rent. However, landlords are probably not going to want to be as forgiving at this moment and just allow tenants to withhold rent. But it is something that tenants may have in their back pocket if they wish to go down the litigation route, which I'll dive into a bit more deeper in a second. One other option within the lease itself is the concept of casualty. Typically, most commercial leases will have a casualty provision. And this is usually drafted in the context of a physical casualty, such as a building being burnt down or a hurricane demolishing a building where the tenant cannot operate. Usually landlords will abate rent or agree in the lease to abate rent for the time period of the casualty. Clearly with the COVID-19 outbreak, no one's really experiencing physical damage, but an argument could be made that the implication of a shutdown by the government is the same as a damage to the property, whereby the tenant cannot actually operate in the space, similar to as if a building was burnt down or a hurricane demolished the premises. So through the legal doctrines that Lauren mentioned, a possible casualty argument, all that leads to a potential litigation with your landlord if the tenant decides to withhold rent. If the tenant decides to withhold rent and not pay for it, and the landlord is not in agreement, there is potential for a landlord to file an eviction. And that will just cause the tenant to go through the court system to argue, their case. Some of these arguments are novel in this context of COVID-19. Some of them have not really been seen at all. So the tenants need to really understand and appreciate the risks they take by trying to go through the court system and the dollars that may have to be spent to defend their position of why rent should not be paid and why they're relying on one of these common law legal doctrines to withhold rent. In Florida, if you're a tenant who's being sued for eviction for not paying rent, in order to defend your position, the courts mandate that you place the disputed amounts with the clerk of the courts in order to even have a defense in court. So tenants need to realize, while you may have an argument based upon legal doctrines, common law, maybe something in the lease itself, you will still be forced to pay the disputed amounts into the court system, pay your lawyer to defend you, and then possibly have an outcome in your favor. When I say possibly, it's because once you get to the court system, there is no definitive answer. So here are some strategies that I think may work without going through the court system and taking the risk of spending dollars on lawyers, as well as placing the unpaid rent amount within the court registry while you defend yourself. One is to open up a dialogue with your landlord. Landlords in the last couple of weeks who I've spoken with, both clients of mine and other colleagues I know who represent landlords, almost all landlords are willing to work with their tenants. And the reasoning is this, is they don't really have a position right now to evict a tenant. Courts are closed for evictions. They're not going to be able to evict anybody, even when they do open up and they can start the eviction process. To get them out of there is going to be a bit of a struggle. And then what's their next option? To find a tenant who's probably struggling in their own right to replace the exiting tenant. So landlords don't want to have vacant spaces. They will more likely than not want to work with you as a tenant in getting your situation to a place where it works for both sides. One option is rent abatement, where a tenant just doesn't pay rent while the business is closed, or a rent deferral. Landlords I've spoken with are leaning towards a rent deferral, where the tenant doesn't pay rent for this period of time, and then the amount of rent that is not paid is just amortized over the balance of the lease term. Some landlords may want to accelerate that. Maybe it's amortized over the next 6 or 8 months, but this is all part of the discussions with the landlord of how best to strategize and make this work for both sides. If you're a good tenant who's been around, paying rent on time, not causing issues, you of course have more leverage than a tenant that may be struggling or missed payments or otherwise in default of their lease. One other argument or position a tenant can make is to not pay rent, but just pay the pass-throughs. If you have a triple net lease, you may just agree to pay the CAM charges, the operating expenses to the landlord while not paying the base rent. And also tenants have the option of looking towards business interruption insurance to help them get them through this period and maybe cover some of their rent costs. My colleague Ben will get into business interruption insurance a bit later on. So just to recap, more likely than not, you're not going to have any express language for giving tenants of the obligation of paying rent due to COVID-19. You may be able to rely on some legal doctrines, common law legal doctrines, to allow you as a tenant to not pay rent, but there is a risk involved going through the court system, making those arguments, any added expenses that go along with it. Like I said, both depositing your rent payment within the courts, as well as legal fees for an uncertain outcome. And then lastly, you could also look to open up a dialogue with your landlord to come to a solution and a compromise that works for everybody, whether it's a rent abatement or rent deferral, just paying pass-throughs or CAM charges, and then of course looking through business interruption insurance. If you have any questions about your specific case, because obviously everybody's lease is a bit different, feel free to reach out. My email is jeremy@accesslawgroup.com. At this point, I will turn it over to my colleague, Andrew Cromer, who will speak about labor and employment considerations and issues in light of the COVID-19 outbreak.
Thank you, Jeremy. Hi, everyone. My name is Andrew Cromer. Today, I'll be covering various employment and HR considerations in light of COVID-19. This area of the law might be the most impacted by COVID-19, with many of the issues taking shape and form in real time. Since there's so much to cover, I thought I'd touch up on a medley of the issues in this space through hypotheticals in the following categories: vacation paid time off, work from home, wage and hour, attendance, and finally, ADA, FMLA. Let's get started. Vacation paid time off. Can an employer require an employee to use their vacation time and/or paid time off to cover the time away from work? The answer is yes, but it's subject to the provisions of the employer's current vacation time and PTO policies, as well as any state laws restricting an employer's ability to amend those policies. Work from home. If you permit an employee to work from home because the employee is concerned about possible contraction of COVID-19 and another employee learned about that arrangement and wants to do the same, can you deny that request because you are concerned that all employees will start working from home? So as a general rule, there is no requirement that an employer must allow all employees to work from home. However, employers should ensure that its workplace policies are administered in a way that does not discriminate against an employee because of that employee's race, color, sex, national origin, religion, age, etc. An employer should be prepared to offer legitimate, non-discriminatory explanation for why it may choose to allow some employees to work from home and not others, and make sure they are consistently applying this reasoning uniformly to all employees. Wage and hour. If you close your business, do you need to pay hourly employees while your business is closed? What about salaried employees? This is a question that we've received numerous times over the past few days. Under federal law, employers are required to pay non-exempt hourly employees only for hours they actually work. Absent employer policies or contractual agreements stating otherwise, these employees are not entitled to be paid during a business shutdown. Of course, non-exempt employees must be paid for all hours worked at a remote location during a shutdown. With limited exceptions inapplicable to COVID-19, federal law requires that exempt salaried employees and non-exempt salaried employees who are paid based on the fluctuating week work method must be paid their entire salaries for any week in which they perform work. And if an employer shuts down its location in the middle of a work week, these employees must be paid their full weekly salaries. So perhaps there's some strategy on when to mandate a shutdown. However, federal law does not require that these employees be paid their salary in any work week in which they perform no work. Employers accordingly would not be obligated to pay such an employee in weeks in which the facility is closed unless the employee continues to work remotely during this time period. Attendance. Can an employee's time away from work resulting from a COVID-19 illness be counted against that employee with respect to an employer's attendance policy? The answer is yes, so long as the illness is not an FMLA qualifying serious health condition, in which case the employer should comply with the FMLA's prohibition on counting these type of absences against an employee. Note that there may be times when complications arising from COVID-19 could be considered a disability, in which case the ADA may be implicated and a reasonable accommodation may be required, such as the modification to the employee's attendance requirements. And finally, FMLA ADA. Is COVID-19 an FMLA covered serious health condition? Not necessarily. If COVID-19 does not satisfy the regulatory definition of a serious health condition, employers should not count the absence against the employee's 12 weeks of FMLA leave. An example of a situation in which the leave may not be FMLA qualifying is when an employee is required by the employer to stay home but is asymptomatic. Is COVID-19 considered a disability? Normally, no. Even under the amended 2009 ADA, The duration of COVID-19 will likely be not long enough to qualify as an ADA disability. Complications from COVID-19, like pneumonia, may qualify as an ADA disability, triggering certain obligations for the employer, like a reasonable accommodation. My hypotheticals are really just the tip of the iceberg on the subject matter to get you thinking about how the employee-employer relationship has been impacted by COVID-19. Please feel free to reach out directly with any specific questions you might have about your business. With that, I turn it over to my colleague, Ben Wolkoff, who will discuss business interruption considerations.
Thanks very much, Andrew. So will your existing business insurance policies cover you based on business losses that you sustain because of coronavirus? Now, obviously, the answer to this depends on the policies you have and the language contained in the policies. But we can make some informed guesses based on what we know about how most major types of policies work. So I'm going to give you a fact pattern that we'll use for our analysis today. It's a little bit of a Miami-centric reference, so for those of you joining us from other parts, text me if some of these references don't quite land. So here's the scenario. You are an empanada maker. You have a huge contract selling empanadas to Publix. You have an exclusive arrangement with a cheese supplier that provides you with all the cheese for your empanadas. Your cheese supplier has had to temporarily shut down due to an outbreak of coronavirus at its facility. You are unable to fulfill certain orders from Publix, and you sustain lost profits as a result. So let's look at BI, or business interruption insurance. Now, this is usually found in your commercial property policy, and it can cover lost profits and a wide array of other losses. So is your loss as the empanada maker covered under your BI policy? The answer is almost certainly no. Although you can show lost sales due to issues at the supplier's facility that prevented you from meeting the order, you can't show direct physical loss or damage to your own facility. And that is a prerequisite under BI policies. Now, what if you're the supplier and not the empanada company? Well, in this scenario, you at least have a fighting chance. You can argue that your facility has suffered physical damage because you and your employees can't occupy and operate the facility as intended. What are your odds of getting coverage? Well, it's important to note that this is not the typical BI insurance scenario such as fire or flooding due to natural disasters. But with some good lawyering and depending on the wording of the policy, you might be able to assert a plausible basis for coverage. Also, note that most BI policies specifically exclude losses caused by virus. But even here, the law interpreting virus exclusions is underdeveloped, and there isn't clear precedent for the circumstances in which many businesses now find themselves based on the prevalence and the scale of this virus. So let's talk about contingent business insurance coverage, which is CBI. Remember, Jeremy referenced that earlier with respect to commercial leases. In this scenario, as the empanada maker, you may be in luck. You may have coverage because this type of insurance provides expanded coverage for losses sustained because of impacts to suppliers and customers, such as work stoppages. And as we know, your cheese supplier had to close shop because of COVID. Here again, there may or may not be limitations or exclusions for viruses or other communicable diseases. Again, and I'll keep saying this, it's very critical that you read the specific language of the policy. What about civil authority or civil ordinance coverage? Well, if in the example above, let's say Miami-Dade County or the state forced the supplier to shut its facility down, or even deemed cheese or empanadas to be non-essential, doubtful by the way, then coverage could be triggered because it applies when a government restricts or denies access to your property. And then that causes you a loss, such as a loss of profits. Again, read the policy. Finally, environmental liability policies. You know, it's unclear if COVID would qualify as a pollutant, so we view this as probably the least likely basis for coverage. And even if it were, the coverage is limited to bodily injury, property damage, and cleanup liability. It would not usually cover lost profits. So these are the most typical policies that are there to cover lost business and property damage. What we haven't spoken about today are the defensive policies, general liability, D&O, errors and omissions. Those are there to protect you from third-party or employee claims, but they may, of course, be very important and come in handy as it relates to this particular pandemic. So real quick, 5 key takeaways. Number 1, take what your insurer tells you at face value. There's a lot of money at stake, and insurers seem to be spreading pessimism to deter businesses from making claims. 2, while there are many sophisticated insurance brokers out there, don't place too heavy a reliance on their review and analysis of your policies. They may also have adopted the insurance company's mantra of no coverage. And this brings us to the third and the most important takeaway: read the policy or engage a lawyer to help you understand the policy. An insurance policy is really just a contract. It's between you and the insurance company. And just as you would hire a lawyer to review a business contract, you should do so for insurance policies. Ambiguity is your friend, and not all policies are drafted as ironclad as you might think they would be. Number 4, document your losses carefully and be mindful of timing requirements of your policies so that you don't prejudice the ability to make an otherwise valid claim. And then finally, keep abreast of legislative and actually that's a good segue to Morgan, who'll speak next about state and local alleviation efforts. But just as a quick anecdote, the state of New Jersey right now is looking at legislation to require insurers to cover COVID-related losses under business interruption insurance policies that otherwise might not have covered them pre-COVID. And so we're always here to help you, so feel free to reach out with us, to us if you have any questions or if you want us to review your policies. And with that, Morgan, the floor is yours.
Thank you, Ben. So as Ben mentioned, state legislatures as well as our federal government have been taking steps, and it seems like the news is changing every day. So it's really important to stay informed. You know, the damage obviously is evident and it's inevitable to our economy, but it's something that's changing, and our elected officials are still figuring it out. So luckily today, everyone should have found out that there has been $2 million stimulus package, $2 trillion stimulus package passed by the Senate. While it does have to pass the House, everyone is optimistic that it should be enacted in the next couple days. The beauty of this package is that it doesn't only benefit airlines and cruise lines and the industries that have been affected, but there are also benefits that can be taken advantage of by businesses and individuals. For example, the government has allotted monies to write checks to individuals up to $1,200 and couples for $2,400, as well as $500 per child under the age of 17. Obviously, these monies are limited if the individual or couple makes above a certain amount. Currently, as drafted, those amounts will be reduced if the individual makes more than $75,000 or if the couple makes more than $150,000. There are hundreds of billions of dollars, I think about $500 billion allotted for a major corporate liquidity program through the Federal Reserve, and it's actually going to be brand new. So time will tell, and we'll see how that actually plays out. In addition, there's $350 billion allotted for the small business loan program. For the bailouts for the travel and hospitality industries, there are restrictions on those loan proceeds. For example, stock buybacks are going to be prohibited during the term of the assistance as well as a year thereafter. And the text of the bill provides that the loan proceeds cannot be used for executive compensation. So there is a nice checks and balances on that. And as drafted, there isn't any type of limitation on the size of business that can be able to participate in this program. Lastly, with regard to businesses, payroll taxes will be deferred as well. With regard to unemployment and individuals who have been out of work as a result of COVID-19, the stimulus deal also has massively expanded unemployment insurance with the goal to ensure that laid off workers will receive on average their full pay for 4 months. And the way this is going to be accomplished is by increasing unemployment benefits by $600 for the maximum employment benefit. So everyone watch the news this week and we'll see how this plays out. And if there are any questions regarding this, again, we welcome the communication from everyone. With regard to unemployment, on the topic of unemployment, last week, the Department of Labor issued guidance, and I encourage everyone to go on the Department of Labor website, dol.gov, where there are tons of links and resources regarding certain grants and benefits. The Department of Labor has allowed states a lot of flexibility as a result of COVID-19 to amend their current insurance benefit programs. And what's nice about this is now federal law does not require an employee to outright quit in order to receive these benefits. And there are certain scenarios that the Department of Labor has laid out where states have that flexibility to amend their laws to provide benefits. And these scenarios include an employer ceasing operations, an employee being quarantined with the expectation to go back to work, and where an employee leaves employment due to the need to take care of a family member. There are also dislocated worker grants, which states can apply for. Specifically, states are eligible where 50 employees have been laid off by one employer, or where there is a concentration of unemployment in a specific community. Lastly, on the federal level, before I talk about Florida-specific efforts, the IRS has declared tax day currently to be July 15th. We'll see if that's a moving target or not. And the federal tax payment deadline is extended regardless of the amount. So that is another way that the government has tried to alleviate some of the financial pressures. Lastly, one quick thing about the SBA loan, and this kind of touches upon what we've been discussing about, is that, you know, a lot of clients will say, well, isn't the SBA or aren't these lenders required to do, required to forgive my payments? Realistically, total forgiveness without a law is probably not likely. However, everyone in the whole world is going through this, and we've encouraged our clients to reach out to their loan brokers and reach out to people to at least get some type of deferment in for the time being, because that's pretty much the norm, what most parties are doing. Now, the last thing I want to touch upon is the Florida Emergency Bridge Loan Program. As it was enacted, $50 billion were allocated for small businesses with 2 to 100 employees. Under this program, small businesses can apply for short-term loans, interest-free, for the first year. Do remember, though, after that first year, interest rates will go up to 12% on the unpaid balance. And if this is something that you as a small business would like to apply for, it's highly recommended that you act quickly. If you want to see the eligibility requirements, as well as information about the loan program, information is available at floridadisaster.biz. And in order to be eligible, the business must have been established before March 9th and must have a place of business in the state of Florida. With regard to changes in the state and whether or not that allotment of money will increase, probably will. And it's a lot of the changes and legislations have been happening on the state and local government level. So time will tell to see who follows who and how the federal government responds. And this is something that we're going to still be following and keeping everyone informed. So now we will turn to question and answers. Lauren will be moderating, and we'll be getting through as many questions that we can based on the ones that have been submitted so far. Even though we're on the questions right now, if questions come up, feel free and type them in. And if we don't get to your question, we will contact you via email and to make sure that you get the information that you are looking for.
So our first question is directed at Jeremy. Someone wrote in that the Florida Association of Realtors recently created a COVID-19 amendment to amend contracts, not new contracts, just existing ones. And one provision of that amendment contractually modifies the financing contingency for deals that are coming towards closing. So the question is, Jeremy, whether we think the mere existence of this type of amendment can be used to argue that the force majeure provision in the form does not allow the buyer to otherwise extend or terminate that date due to the force majeure.
Sure. So in the typical FAR-BAR contract, the force majeure provision of the language, in my opinion, doesn't truly cover a pandemic. The only language that one may be able to rely on is the general catch-all, other acts of God. I have a feeling that the interpretation of an act of God may be litigated in the coming months with respect to force majeure and letting folks out of a contract. But on its face, and I don't believe a pandemic is captured in the FAR-BAR contract, and perhaps that's why the Florida Realtors Association came out with this COVID-19 amendment a few days ago. One thing to keep in mind is both parties have to agree to execute it. So if one party wants to and the other party doesn't, then it's not effective. The force majeure provision of the FAR-BAR contract captures hurricanes, floods, extreme weather, earthquakes, fire, acts of God, unusual transportation delays, or wars or insurrections or acts of terrorism. So again, I don't know if pandemics would fall under that definition on its face. With respect to the financing, if the COVID-19 amendment is going to be executed and the lender doesn't fund due to the COVID-19 outbreak, the buyer may have an out and may be able to terminate based upon the lender not funding. However, in absence of the COVID-19 amendment being executed and the lender doesn't fund, the buyer may, while still be obligated to close pursuant to the terms of the contract, if all contingencies have expired and the lender still doesn't fund after the buyer has received a loan commitment or a loan approval, the buyer may have an issue with their lender. But in reality, in my experience dealing with similar issues, obviously not in the pandemic area, when push comes to shove, parties will get a deal done, but there could be an outstanding issue between lender and buyer if the lender doesn't fund after providing a loan commitment.
Thank you. Next, we have a question that's directed to Morgan, and it is, does the government owe small businesses just compensation for forcing them to close for the public good?
Thank you for the question. Currently, based on the text of the bill on the federal level, unfortunately, there is no outright gift or just compensation for these businesses. The money that is allotted by the federal government is in the form of loans. However, time will tell if there are other benefits that will be available for businesses that have been ordered to shut down as a result of government action. So depending where you're located, it's important to stay abreast of the updates in your state and local legislatures as well. But at this point, there is no outright just compensation, unfortunately.
The next question that we have is one directed towards Andrew. And it is, if you furlough an employee and they are unpaid, what happens if they cannot pay and or afford their portion under coverage?
Got it. First of all, I'm doing my best not to touch my face, but I feel like every minute I'm like scratching. So I'm trying to lead by example up here, but I know this is being recorded. So For those that don't know what furlough is a mandatory suspension from work without pay. Some employers are taking that tactic right now. The benefit is, when we get through this, your employee is technically still onboarded. They get to maintain their benefits. So there's a laundry list of reasons why one might do it, one might not do it. But, I think to answer this specific question, I think employers need a plan with their employees, how the employees are going to maintain their monthly premium contributions to maintain coverage during this unknown period. The question implies that the employee is contributing some aspect to health coverage. So, failure for them to contribute their monthly premiums could cause coverage to lapse. And obviously they would lose health, dental, vision, etc. So, I think the best practice is to come up with an arrangement with your employee in advance to understand how they'll contribute to those programs in order for them to maintain coverage. But, if they don't pay their portion and that's what's owed, sadly, the coverage will lapse.
We next have an additional question for Morgan, and it relates to benefits being available or not available in the event an employee outright quits.
So the question, just to clarify, is, does an employer have to quit in order to receive these benefits that I was referencing via the Department of Labor guidance? And generally, while that's true, these specific benefits that are now potentially available by allowing states to amend their benefits programs are now available for employees who don't outright quit, because the scenarios where these changes take place is if an employer shuts down and the employee can't work. That's a scenario where the employee isn't quitting. If an employee becomes ill and has to quarantine with the expectation of returning back to work, in that case, the employee isn't quitting, essentially kind of like a sabbatical, but under the DOL guidance, states are permitted to amend their insurance laws to account for these types of scenarios. And lastly, if an employee has to leave in order to take care of a loved one or a family member, and keep in mind, this comes with a caveat that the states aren't automatically doing this in order to provide for these benefits under the scenarios, but the Department of Labor guidance is now allowing states that flexibility to amend their laws in a more seamless and easier, quicker fashion in order to protect these employees who are now out of work under these scenarios.
Jeremy, this one might be for you, but it's regarding leases and whether the same legal doctrines would apply to non-real estate leases like autos and trucks, office equipment, medical equipment, manufacturing plant equipment. I can also chime in here. I think the same contract enforceability analysis that I provided in the beginning of the webinar would apply, where you have to look to the actual contract or underlying lease agreement to see if there are any explicit contractual provisions dealing with that. In terms of whether there's similar remedies as with real estate leases, Jeremy, do you have any thoughts on that?
Without much more context, it'd be hard to really pinpoint an answer, but generally speaking, I would think that the similar legal doctrines could apply. Obviously, the terms of the contract would be the first place to look, and then on the context, whether performance could be delayed due to impracticability or impossibility of performance. And a similar analysis would be performed with respect to car leases or trucking or things of that nature.
Let's see. Just going through here. Let's see. There was a question about what constitutes Florida as a place of business, whether an employee of Florida or do you need a registered business in the state? So whether you need to register the business in the state is going to be dependent on if you've gone through the analysis of figuring out whether you're conducting business in Florida. However, there's a lot of different factors that go into that analysis, and we might want to reach out to this person individually to have that discussion with them. Typically, if you have employees within the state, that will sort of get you there rather than, isolated incidents of having services conducted there entering into contracts. But we'll reach out to this person.
And sorry, Lauren, sorry to interrupt. And to add to that, for the answer to that question, the full eligibility requirements are available on the Florida's government website, which is floridadisaster.biz. And it's going to list all of their requirements and the information, what's required. It's laid out pretty clearly and should be clear from the application that's online.
Okay, perfect. I think that is all of the questions. Somebody asked if this webinar is going to be available. We have recorded it and I'm going to see where I can post it online. So we'll definitely reach out or send an email to the attendees just letting you know how to access it. And I think that was all of our questions. So I guess we'll take this time to thank everybody for coming. I hope that we were able to help with some of the information we provided and answer some of your questions. That being said, I know that new questions are popping up on the daily occurrence just because everything's changing so quickly. So you have our emails on here. Please feel free to reach out to us if you want to continue any of the dialogue, and we'll also be available whenever you need us in the upcoming weeks. And we also hope to do some more of these webinars, so stay tuned. We have you on our email list, and stay safe. Thanks, everybody.
Thank you, everyone.
Yeah.
Bye.
Oh no.
I think you're still on, Lauren.
Yes, I thought I just did some deletion. If yes, you will receive.